in part. D, imposing measures intended to prevent births within the group. E, forcibly transferring children of the group to another group. End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. The Court considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. As the Court has stated in other cases, in order for acts to fall within the scope of Article 2 of the Convention, the intent must be to destroy at least a substantial part of a particular group. This is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. The Palestinians appear to constitute a distinct national, ethnical, racial, or religious group, and hence a protected group within the meaning of Article 2 of the Genocide Convention. The Court observes that, according to United Nations sources, the Palestinian population in the Gaza Strip comprises over 2 million people. Palestinians in the Gaza Strip form a substantial part of the protected group. The Court notes that the military operation being conducted by Israel following the attack of 7 October 2023 has resulted in a large number of deaths and injuries, as well as massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure. While figures relating to the Gaza Strip cannot be independently verified, recent information indicates that 25,700 Palestinians have been killed, over 63,000 injuries have been reported, over 360 housing units have been destroyed or partially damaged, and approximately 1.7 million persons have been internally displaced. The Court takes note in this regard of the statement by the United Nations Undersecretary General for Humanitarian Affairs and Emergency Relief Coordinator, Mr. Martin Griffiths, on 5 January 2024. I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. A public health disaster is unfolding. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence while the world watches on." End of quote. Following a mission to North Gaza, the World Health Organization reported that as of 21 December 2023, I quote, "an unprecedented 93% of the population of Gaza is facing crisis levels of hunger, with insufficient food and high levels of malnutrition." End of quote. The Court further notes the statement issued by the Commissioner General of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, or UNRWA, Mr. Philippe Lazzarini, on 13 January 2024. I quote, "It's been 100 days since the devastating war started, killing and displacing people in Gaza following the horrific attacks that Hamas and other groups carried out against people in Israel. It's been 100 days of ordeal and anxiety for hostages and their families. In the past 100 days, sustained bombardment across the Gaza Strip caused the massive displacement of a population that is in a state of flux, constantly uprooted and forced to leave overnight, only to move to places which are just as unsafe. This war affected more than 2 million people, the entire population of Gaza. Many will carry lifelong scars, both physical and psychological. The vast majority, including children, are deeply traumatized. Overcrowded and unsanitary UNRWA shelters have become home to more than 1.4 million people. They lack everything, from food to hygiene to privacy. People live in inhumane conditions where diseases are spreading, including among children. They live through the unlivable with the clock ticking fast towards famine. The plight of children in Gaza is especially heartbreaking. An entire generation of children is traumatized and will take years to heal. Thousands have been killed, maimed, and orphaned. Hundreds of thousands are deprived of education. Their future is in jeopardy with far-reaching and long-lasting consequences. The UNRWA Commissioner General also stated that the crisis in Gaza is, I quote, compounded by dehumanizing language, end of quote. In this regard, the court has taken note of a number of statements made by senior Israeli officials. It calls attention in particular to the following examples. On 9 October 2023, Mr. Yoav Gallant, Defense Minister of Israel, announced that he had ordered a complete siege of Gaza City, and that there would be no electricity, no food, no fuel, and that everything was closed. On the following day, Minister Gallant stated, speaking to Israeli troops on the Gaza border, I quote, "I have released all restraints. You saw what we are fighting against. We are fighting human animals. This is the ISIS of Gaza. This is what we are fighting against. Gaza won't return to what it was before. There will be no Hamas. We will eliminate everything. If it doesn't take one day, it will take a week, it will take weeks or even months. We will reach all places." End of quote. On 12 October 2023, Mr. Isaac Herzog, President of Israel, stated, referring to Gaza, I quote, "We are working, operating militarily according to rules of international law, unequivocally. It is an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. They could have risen up. They could have fought against that evil regime which took over Gaza in a coup d'etat. But we are at war. We are at war. We are at war. We are defending our homes. We are protecting our homes. That's the truth. And when a nation protects its home, it fights. And we will fight until we break their backbone." End of quote. On 13 October 2023, Mr. Israel Katz, then Minister of Energy and Infrastructure of Israel, stated on X, formerly Twitter, I quote, "We will fight the terrorist organization Hamas and destroy it. All the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world." End of quote. The court also takes note of a press release of 16 November 2023 issued by 37 special rapporteurs, independent experts, and members of working groups part of the special procedures of the United Nations Human Rights Council, in which they voiced alarm over, I quote, "discernibly genocidal and dehumanizing rhetoric coming from senior Israeli government officials." End of quote. In addition, on 27 October 2023, the United Nations Committee on the Elimination of Racial Discrimination observed that it was highly concerned about the sharp increase in racist hate speech and dehumanization directed at Palestinians since 7 October. In the court's view, the aforementioned facts and circumstances are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. The Court then turns to the condition of the link between the plausible rights claimed by South Africa and the provisional measures requested. It considers that by their very nature, at least some of the provisional measures sought by South Africa are aimed at preserving the plausible rights it asserts on the basis of the Genocide Convention in the present case, namely, the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. Therefore, a link exists between the rights claimed by South Africa that the Court has found to be plausible and at least some of the provisional measures requested. The Court turns next to the question of risk of irreparable prejudice and urgency. It notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights might entail irreparable consequences. However, the power of the Court to indicate provisional measures will only be exercised if there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decisions. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes the final decision in the case. The Court must therefore consider whether such a risk exists at this stage of the proceedings. The Court is not called upon for purposes of its decision on the request for the indication of provisional measures to establish the existence of breaches of obligations under the Genocide Convention, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under that instrument. As already noted, the Court cannot at this stage make definitive findings of fact, and the right of each party to submit arguments with respect to the merits remains unaffected by the Court's decision on the request for the indication of provisional measures. The Court recalls that, as underlined in General Assembly Resolution 96-1 of 11 December 1946, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End of quote. In view of the fundamental values sought to be protected by the Genocide Convention, the Court considers that the plausible rights in question in this proceeding, namely, the right of Palestinians in the Gaza Strip to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention, and the right of South Africa to seek Israel's compliance with the latter's obligation under the Convention, are of such a nature that prejudice to them is capable of causing irreparable harm. During the ongoing conflict, senior United Nations officials have repeatedly called attention to the risk of further deterioration of conditions in the Gaza Strip. The Court takes note, for instance, of the letter dated 6 December 2023, whereby the Secretary-General of the United Nations brought the following information to the attention of the Security Council. I quote, "The healthcare system in Gaza is collapsing. Nowhere is safe in Gaza. Amid constant bombarding by the Israel Defense Forces and without shelter or the essentials to survive, I expect public order to completely break down soon due to the desperate conditions rendering even limited humanitarian assistance impossible. An even worse situation could unfold, including epidemic diseases and increased pressure for mass displacement into neighboring countries. We are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region. Such an outcome must be avoided at all costs." End of quote. On 5 January 2024, the Secretary-General wrote again to the Security Council, providing an update on the situation in the Gaza Strip and observing that, I quote, "Sadly, devastating levels of death and destruction continue." End of quote. The Court also takes note of the 17 January 2024 statement issued by the UNRWA Commissioner General upon return from his fourth visit to the Gaza Strip since the beginning of the current conflict in Gaza. I quote, "Every time I visit Gaza, people have sunk further into despair, with the struggle for survival consuming every hour." End of quote. The Court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted inter alia in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The Court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war, I quote, "will take many more long months." End of quote. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. The World Health Organization has estimated that 15% of the women giving birth in Gaza Strip are likely to experience complications and indicates that maternal and newborn death rates are expected to increase due to the lack of access to medical care. In these circumstances, the Court considers that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating further before the Court renders its final judgment. The Court recalls Israel's statement that it has taken certain steps to address and alleviate the conditions faced by the population in the Gaza Strip. The Court further notes that the Attorney General of Israel recently stated that a call for intentional harm to civilians may amount to a criminal offense, including that of incitement, and that several such cases are being examined by Israeli law enforcement authorities. While such steps are to be encouraged, they are insufficient to remove the risk that irreparable prejudice will be caused before the Court issues its final decision in the case. In light of the foregoing, the Court considers that there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights found by the Court to be plausible before it gives its final decision. The Court concludes, on the basis of the aforementioned considerations, that the conditions required by its statute for it to indicate provisional measures are met. It is therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the rights claimed by South Africa that the Court has found to be plausible. The Court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the Court finds that the measures indicated need not be identical to those requested. The Court considers that, with regard to the present situation, Israel must, in accordance with its obligations under the Genocide Convention, in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, a. killing members of the group, b. causing serious bodily or mental harm to members of the group, c. deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and d. imposing measures intended to prevent births within the group. The Court recalls that these acts fall within the scope of Article 2 of the Convention when they are committed with the intent to destroy in whole or in part the group as such. The Court further considers that Israel must ensure with immediate effect that its military forces do not commit any of the aforementioned acts. The Court is also of the view that Israel must take measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to the members of the Palestinian group in the Gaza Strip. The Court further considers that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. Israel must also take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention against members of the Palestinian group in the Gaza Strip. Regarding the provisional measure requested by South Africa that Israel must submit a report to the Court on all measures taken to give effect to the order, the Court recalls that it has the power, reflected in Article 78 of the Rules of Court, to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the Court considers that Israel must submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order. The report so provided shall then be communicated to South Africa, which shall be given the opportunity to submit to the Court its comments thereon. The Court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The Court reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions related to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of the Republic of South Africa and the State of Israel to submit arguments in respect of these questions. The order then states that the Court deems it necessary to emphasize that all parties to the conflict in the Gaza Strip are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the Court indicates the following provisional measures. 1. By 15 votes to 2, the State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Branch, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall ensure with immediate effect that its military does not commit any acts described in point 1 above. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 16 votes to 1, the State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt. Judges ad hoc, Barak, Moseneke. Against, Judge Sebutinde. By 16 votes to 1, the State of Israel shall take immediate and effective measures to ensure the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt. Judges ad hoc, Barak, Moseneke. Against, Judge Sebutinde. By 15 votes to 2, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide against members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt. Judge ad hoc Moseneke. Against, Judge Sebutinde, Judge ad hoc Barak. By 15 votes to 2, the State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 month as from the date of the order. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt. Judge ad hoc Moseneke. Against, Judge Sebutinde, Judge ad hoc Barak. I shall now call upon the Registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1. Par 15 voix contre 2, l'État d'Israël doit, conformément aux obligations lui incombant au titre de la Convention pour la prévention et la répression du crime de génocide, prendre toutes les mesures en son pouvoir pour prévenir la commission, à l'encontre des Palestiniens de Gaza, de tout acte entrant dans le champ d'application de l'article 2 de la Convention, en particulier les actes suivants. A. Meurtre de membres du groupe. B. Atteinte grave à l'intégrité physique ou mentale de membres du groupe. C. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. Et D. Mesures visant à entraver les naissances au sein du groupe. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 2. Par 15 voix contre 2, l'État d'Israël doit veiller avec effet immédiat à ce que son armée ne commette aucun des actes visés au point 1 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 3. Par 16 voix contre 1, l'État d'Israël doit prendre toutes les mesures en son pouvoir pour prévenir et punir l'incitation directe et publique à commettre le génocide à l'encontre des membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Messieurs Barak, Moseneke, juge ad hoc, contre Madame Sebutinde, juge. 4. Par 16 voix contre 1, l'État d'Israël doit prendre sans délai des mesures effectives pour permettre la fourniture des services de base et de l'aide humanitaire requis de toute urgence afin de remédier aux difficiles conditions d'existence auxquelles sont soumis les Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brandt, juge, Messieurs Barak, Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge. 5. Par 15 voix contre 2, l'État d'Israël doit prendre des mesures effectives pour prévenir la destruction et assurer la conservation des éléments de preuve relatifs aux allégations d'actes entrant dans le champ d'application des articles 2 et 3 de la Convention pour la prévention et la répression du crime de génocide commis contre les membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brandt, juge, Monsieur Moseneke, juge ad hoc, contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 6. Par 15 voix contre 2, l'État d'Israël doit soumettre à la Cour un rapport sur l'ensemble des mesures qu'il aura prises pour donner effet à la présente ordonnance dans un délai d'1 mois à compter de la date de celle-ci. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brandt, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc.
Judge Choué appends a declaration to the order of the court. Judge Sebutinde appends a dissenting opinion to the order of the court. Judges Bandari and Nolte append declarations to the order of the court. Judge Ad hoc Barak appends a separate opinion to the order of the court. The text of the court will be available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.
Perhaps this will help the Biden administration because, as we know, behind the scenes, the US president has been urging the Israelis to stop the scale of their bombardment and to tone down some of their military operations and to scale up the humanitarian aid, all of things that have been ignored by Israel until this point. So I suspect the Biden administration may well, given the way this has gone, be somewhat happy with this, but we'll have to see what comes out of Washington in the coming hours. And of course, it's not just the US. When you look at the international landscape, most of the international community is now believing in the idea that there should be an immediate ceasefire. Yes, there are some European countries too that support Israel's right to self-defense, but notable ones among those are the UK and Germany, who keep talking rather confusing language about the need for a sustainable ceasefire. What do they mean by that? When you get into the details, they mean a ceasefire that can be sustained once Hamas has been defeated. So in effect, it's no different from the US, or for that matter, the Israeli position.
All right, James, being there for the moment, James Bayes at The Hague there. Let's cross to the heart of it all, to southern Gaza, to Rafah. Our correspondent, Hani Mahmoud, joins us from there. Hani, people were waiting in anticipation for these rulings, not the clear-cut call for a ceasefire that South Africa and Palestinians and their supporters wanted.
Deal of frustration and resentment, because the one element that every single Palestinian across the Gaza, probably including the children, were waiting for, which is an end to this madness, an end to cessation to all hostilities, the ongoing intense bombing. They were waiting for that statement. One statement could have relieved an entire population, largely displaced and more profoundly traumatized as the bombing continued across the Gaza. To the time the statement was read, there was still bombing going on in the city of Khan Yunis and the northern part. That one element that everybody waited for. People have been saying that for weeks now. There is ongoing systematic killing of the people in Gaza. The UN warned of famine. We have the Deputy General of the United Nations warned of systematic destruction of civic institutions and this systematic destruction of every means of life, turning Gaza into an uninhabitable place and forcing people into expulsion. People were waiting that this is continuing because of the mass bombing that has been relentless, been very destructive, and has turned Gaza into a death camp so far. That one line, despite all the positive rulings, but they just wanted this to end because people are tired, they're exhausted, they want to go back to their homes, they want to see remaining family members, they want to go back to normal life. But the statement did not give them that, and that's why they're continuing to be restless.
All right, Hani, thanks for that. Hani Mahmoud in southern Gaza. Let's discuss this with analyst Mark Bashar. So, it's somewhat complex and opaque, isn't it? Israel must take all measures to stop killing members of the group, Palestinians, or harming them, and stop taking measures to jeopardize birth control. I mean, if they're not going to do that, then effectively it's going to be business as usual, isn't it?
Well, yes, but it wasn't going to do that any which way, Nick. No. Israel wasn't going to abide by the ICJ ruling any which way, and it said that from the outset. So that's why, for me, although there's discussion to be had about the provisional measures and why the court embraced its own measures rather than those of South Africa, but for me, this is a court of justice. And the fact that they went for almost 36 minutes making the case, they basically made the case why, first of all, there is a dispute between South Africa and Israel, that they accept that South Africa has a right to take this up to the ICJ. And second, and that's the most important for me, headline today, that the ICJ has jurisdiction in the case of Gaza. That means it suspects there is genocide taking place in Gaza. It will take up the case. And the way the Judge Donahue, the head of the court, went on and on and on, making the case, basically, she sounded like a South African prosecutor, basically saying, look, here is the circumstance. Here's what Israel has done. Here what Israel is doing. Here is what the various United Nations agencies' heads have said. Griffin, Under Secretary General, the WHO, UNRWA, and so on and so forth. And then going on and showing intent. Gallant, Herzog, Katz, and so on and so forth. So they basically were making the case that there is every evidence that could lead to the fact that Israel is carrying a genocide in Gaza. Okay? And that then Israel must refrain from doing 1, 2, 3, 4, 5. asked first and foremost for a ceasefire. The world is asking for a ceasefire. But the principle here for a court of justice to say, such as the ICJ, and although the bar is not as high as when they will in fact discuss this down the road and judge whether Israel is or is not in fact carrying genocide, the fact that they accepted the case, the fact that they are putting Israel on notice, and the fact that they want reports from Israel moving forward and expect certain results from Israel, I think that's in a big way is a big win for South Africa.
Okay, so there's that, but they did not apply the South African measures, the measures that South Africa has called for. Why that discrepancy?
Of course, I don't know what goes on in their minds, but I would have preferred that this gone the Myanmar way and saying, in some Chinese stuff. If they've gone the Bosnia way, right? They've gone through the Bosnia ruling, namely suggesting a whole number of things that Israel shouldn't do, especially on the fact that they shouldn't take any acts that contravene the Genocide Convention, that they should allow for humanitarian aid, that they should maintain the records of decision-making to show intent and so on and so forth. I am saddened by the fact that there is no ceasefire, but then I am not as saddened because I knew Israel was not going to carry on with that ceasefire. Now, let me tell you why, and we had this conversation the past hour about the diplomatic and strategic implications for this. We knew from the past 2 weeks that Israel was not going to abide by any ceasefire. The fact here is that the United States now needs to look in the mirror. The UK, Germany, and other countries who supported Israel the last 3 months unconditionally need now to look in the mirror and reconsider the decision, because the court of the land, the court of the world, the court of the United Nations have taken up the case of genocide against Israel for its actions the past 3 months. That the principle of it, that it would take on the case and then it would put Israel on notice and demand of it a number of things. I think legally and morally, for me, it's more important. Morally speaking, that sends a strong message to Israel and its backers that they need to cease and desist, even if the court did not spell it.
Okay, but the chances are, as you say, that Israel will just carry on the way they're
Ben je in de auto?
Dat is mooi.
Ja, hè? Ja.
בואו צריך להתקרב אז לבחור הזה, אדם. איפה נדע?
ישראל לא
So how come you're here? Your journey? Video? No. So, tell me in 2 sentences what happened inside. Was Israel being slapped on the fingers? Yeah, but they didn't go all the way. Ceasefire, they didn't say. And that's a pity. Are you disappointed? You're neutral. But it's just keeping us busy. Yeah. Are you from the
Oui, pardon. Non, parce qu'en vrai, je pense que comme la dernière fois, il va se mettre un peu loin. Je vais venir. Oui.
What's the biggest city of the world? Oh, yeah. Oh, yeah, that's tourist.
If you're tapping your own camera, that's your problem.
Good for you.
Okay, see what, we'll do a trick. We'll do a ceasefire.
Okay. All the way, all the time for Bloomberg. And in India you were also recording. So you were into your
Dann weißt du ja, wo ich stehe, dass ich dich sehen kann, dass die 1 in meine Richtung zeigt. Okay, ich glaube, da kommt der Vertreter.
We are about to bring the minister, but she has been called back just for a quick 10 minutes meeting. So we'll bring her after 10 minutes. 10 minutes. Thank you for that.
Das ist 1/3. Ich kann das jetzt wechseln. Kannst du das Mikrofon ein bisschen frei nehmen? You see, it's
hope it doesn't blow over.
Yeah, brilliant. Thank you so much.
But you can also hang it in one of these cords, the topics, and then it will never fall.
But I don't think it's a good tool. But the other is a good tool. But I think it's together.
Thank you.
Ja,
Wordt je steeds losser? Ja, wij zijn niet in dienst van de ICT. Wel met dit soort dingen.
Yes, I am. My code is up here for the foreigners.
Wat vond je nu naar buiten is?
كل اقتراحاتك مقبولة.
Good afternoon, ladies and gentlemen of the media. We've just come out of court, as you know. Do you want me to give you a minute? Are you all right?
Yes, you are right.
Okay. So we have the Minister of International Relations and Cooperation of South Africa, Dr. Naledi Pandor, who's going to speak to you. The Director General of the Foreign Ministry and Home, Mr. Zain Dango. Omar, yeah, I'm sure you know him. So the minister is going to speak, and then Omar is going to speak as well. DG will take questions. You all ready?
Yes.
Good to go. Minister, over to you.
My name is Naledi Pandor, and I'm the South African Minister of International Relations and Cooperation. I wish to begin by thanking the judges of the International Court of Justice for dealing with this matter expeditiously, given the urgency of the need to protect innocent civilians in Palestine and to ensure that the harm that South Africa has referred to in the case it brought before the ICJ, that harm is addressed and that people's lives are saved. The saving of life is not merely with respect to having a ceasefire, it's to ensuring that humanitarian aid is provided to those who need support, as well as ensuring that the State of Israel, which is currently the occupier and administrator in Palestine, provides the necessary basic services that the residents of Gaza and the West Bank require. This case was very much about international bodies ensuring that they exercise their responsibility to protect us all as global citizens. All member states of the United Nations have attached their signatures to a range of instruments. But when lives are threatened, these instruments are not brought to bear. And South Africa had the view that we could not stand idly by and continue to observe the killing of thousands of Palestinian citizens who had no role in the awful act of hostage-taking and killing that was done by Hamas. And therefore, we thought it important that we do report and apply to the International Court of Justice that the measures provided within the Convention for the Punishment and Prevention of Genocide are brought to bear, and that the State of Israel is called upon by the judges to act to protect civilians and to end the massive level of harm that we have seen since the Israeli action began, and we agree entirely with the judges that Hamas should release the hostages that they're currently holding. We also, in our various engagements with our partners internationally, believe the moment is now ripe for there to be negotiations for a two-state solution to end this conflict decisively.
Minister, are you disappointed there isn't a ceasefire? Are you disappointed the court?
I believe that in exercising the order, there would have to be a ceasefire. Without it, the order doesn't actually work. I would have wanted a ceasefire. No, they didn't.
Are you disappointed
but how,
they didn't specify that?
I have no way that I'm going to say I'm disappointed. I hoped for it, but the fact of delivering humanitarian aid, the fact of taking measures that reduce the levels of harm against persons who have no role in what Israel is combating, for me requires a ceasefire. And I believe Israel would have to attend to how it conducts its search for the hostages and for those Hamas individuals who carried out the October 7 attack.
What's the next step?
I believe that the court judgment needs to be read very, very carefully. They've given very, very direct instructions. We are satisfied that the provisional measures that we sought to be addressed would be addressed by the court. And I believe if you read the convention very carefully, the matter of how a war or conflict is conducted is not elaborated. I would have wanted that the word cessation is included in the judgment. But I am satisfied with the directives that have been given. And in particular, I was concerned as the president of the court was reading the order that of action in terms of the order is vital. And so for the fact that a monthly report, a report within 1 month of this date, has been ordered is, I believe, very significant.
But what do you say to Germany and the United States who have called this case meritless?
Well, the fact that the court says, remember that today we're not deciding about the allegation of genocide. What we're dealing with are the provisional measures. It's clear that the court does say circumstances exist where it is plausible that genocidal acts have been committed. This, of course, means once the merit case is addressed, and if the finding is that there has been genocide, those states that have aided and abetted become a party to commission of an infringement in terms of the convention.
Do you think Israel will conform to the orders laid down by the court today?
I've never really been hopeful about Israel, but Israel has very powerful friends who I hope will advise Israel that they should act in terms of the order.
Would you say, what does it say about Israel as a country and a government and a military?
I think that's for you and the public to decide. What we've said is, here's an international instrument, let us bring it into operation, and let's stop being observers of significant harm. Let's act, and South Africa has acted. And what the court has actually indicated is that this convention is being brought to life in a very practical way. And I now think what we want is that the member states of the United Nations must oversee the process and ensure that we create a basis for a global community in which a resort to arms is no longer easy. A resort to abuse is no longer easy, and that more effort is now directed toward negotiation and toward seeking peaceful means of ending conflict.
And do you think Hamas behaved genocidally?
Well, as far as I understand the convention, states are members, states are signatories, and you bring actions with reference to states, not to particular groups.
But has Hamas behaved genocidally?
Well, I believe that what has been done by Hamas is certainly caused great harm, and I do think that the hostages should be freed, and that's what we must focus upon.
Madam Minister,
okay,
do you believe that the decision of the court will help, let's say, in solving the
the problem of the Israeli aggression against the Palestinians today, and in the short term maybe can help finding a political solution to the conflict between the Palestinian people and the Israeli occupation.
Well, my hope is that we will begin to move toward a process where substantively a two-state solution is being discussed. The people of Palestine have suffered harm for many, many decades. I don't believe it will end today or tomorrow. But what we've done is a very clear signal has been sent by the court. And it's now a test for the government and people of Israel as to whether they will act in a manner that says all of us must respect international law.
Could you tell me?
What are the implications for international law?
Hello.
Well, if Israel acts in accord with it, I think the implications are for a future hopeful world. Should it not, then essentially we are opening up room for all abusers in many conflicts throughout the world. And I think we'll be setting a terrible, terrible precedent. So what we should do, what all of us should do, is call on Israel to act in terms of the decisions.
Will you sever ties with Israel, or are you preserving ties with Israel?
I don't think it's a matter of South Africa and Israel here. The real issue, all your questions are about Israel, but the real issue is the people of Palestine who are being killed every day. The people of Palestine who are sleeping in the cold. The people of Palestine who are denied food, water, and energy. That is the critical issue that all of us should focus upon.
Yeah. And on that note, we're going to ask the Vice Foreign Minister of...
That with the people of Palestine, we stand with the people of Palestine, and our message to them is never give up hope. South Africa got over the apartheid oppression. They will overcome.
And for that, we'll ever be grateful, Your Excellency.
Thank you.
Allow me to start by saying that we concur with everything that Her Excellency, the Minister of International Cooperation of South Africa, Naledi Pandor, has stated in front of all of you, and to read a message from the Palestinian people on this very important day. This is a historic day. Palestine welcomes the momentous order by the International Court of Justice. This order means that the court recognized the gravity of the situation and was convinced by South Africa's compelling presentation that was based on law and fact that there are plausible cause to believe that Israel is committing genocide in Gaza. It means that the cries and suffering of our people in Gaza have been heard in the Great Hall of Justice. Israel failed. It failed to convince the court to dismiss the complaint to prove that it is not deliberately violating Genocide Convention. The ICJ judges assessed the facts and the law and issued their order. Israel now will stand trial accused of committing the crime of all crimes. We call on states to ensure that all provisional measures ordered by the court are implemented. States and governments have clear obligations in light of this order. First and foremost, they must make sure they are not complicit in this genocide. This is a good day for humanity. This ruling is in favor of international system based on law and against exceptionalism and double standards. It should be a wake-up call for Israel and its enablers. The State of Palestine will undertake every endeavor to follow up on this important ruling by the courts towards ensuring the rights of the Palestinian people and ensuring justice. To this end, and with deep conviction in the rule of law, we will continue pursuing accountability and justice in all forms, including in the few weeks' time when we return here to the ICJ on the 19th of February for the oral hearings in the advisory opinion proceedings on Israel's illegal occupation and regime inside the occupied Palestinian territory. This illegal occupation and apartheid regime must be brought to an end. Palestine will forever be grateful to South Africa for taking this bold step of active solidarity, together with peace-loving nations we will continue to work to stop genocide, hold perpetrators to account, and work to stop all other atrocities against our people. Just few words in Arabic and I'll conclude my statement and open the way for questions and answers. هذا يوم تاريخي لفلسطين والإنسانية جمعاء. ترحب فلسطين بقرار محكمة العدل الدولية الحاسم فيما يخص الإجراءات الاحترازية الواجبة بخصوص الشكوى المقدمة من جمهورية جنوب أفريقيا حول الإبادة الجماعية التي تشنها إسرائيل على الشعب الفلسطيني في قطاع غزة. هذا يعني أن إسرائيل ستحاكم في قادم الأيام بتهمة الإبادة الجماعية وانتهاكات أخرى لمعاهدة الإبادة الجماعية في أعلى سلطة قضائية في العالم. لقد فشلت إسرائيل في التهرب من المساءلة، فشلت في تبرير ما ترتكبه من فظائع. قضاة محكمة العدل الدولية قيموا ما قدم لهم من حقائق ووقائع ومعطيات قانونية من قبل جنوب أفريقيا، ولم يتأثروا بمحاولة دولة الاحتلال لتسييس ما قدمته أو تحريف أو أكاذيب. هذا الحكم هو انتصار للقانون الدولي والإنسانية ورفض واضح للفوضى والمعايير المزدوجة. هذه رسالة واضحة لدولة الاحتلال وداعميها بأن لا أحد فوق القانون أو خارج نطاق المساءلة. لقد ولت أيام الإفلات من العقاب. في هذا السياق ندعو جميع الدول إلى ضمان تطبيق الحكم الصادر من المحكمة اليوم والالتزام بمسؤولياتهم بمقتضى هذا الحكم، وتحديدا بأن لا يساعدوا حكومة الاحتلال بارتكاب مزيد من الجرائم وأن لا يتورطوا أو يتواطؤوا في ارتكاب هذه الجرائم، وتحديدا مسألة تزويد إسرائيل بالسلاح. أختتم بتأكيد امتنان القيادة الفلسطينية والشعب الفلسطيني لشعب وحكومة جنوب أفريقيا لاتخاذ هذه الخطوة الجريئة من التضامن العملي، وسنواصل جنبا إلى جنب مع الدول الأخرى صاحبة المبادئ والشعوب العمل على وقف الإبادة الجماعية ومحاسبة إسرائيل على فظائعها ضد الشعب الفلسطيني والدفاع عن حقوقنا الجماعية كشعوب العالم في المساواة في حقوق الإنسان. هذه معركة علينا أن ننتصر فيها من أجل الحرية والإنسانية. شكرا.
Sir, can you tell us what the implications of this ruling are for Israel's allies, especially the US and the UK?
The implications are that they have direct responsibilities as of now not to be complicit in any of the crimes that Israel is committing in the Gaza Strip, not to provide any assistance to these crimes, and to hold Israel to account while it makes these crimes.
ما هي الخطوة المقبلة سعادة السفير؟ سعادة السفير.
If Israel was to comply with the ruling, it did in fact, even though it wasn't specified, it means they have to have
The order cannot be implemented in any way, shape or form.
How do you transport humanitarian aid without a ceasefire?
Exactly.
How would you provide water, access to energy? How do you ensure that those who are injured have health care and so on? Without a ceasefire, none of these things can be done. So if you read the order by implication, a ceasefire must happen.
Yes. The order cannot be implemented in any way, shape or form without a ceasefire. It's as simple as that. I think in each and every aspect of the order there is a call for a ceasefire.
I'm not President Biden, so I can't answer for him. I think you'll have to ask him. But I'm sure, as a humanitarian, he would support any action that seeks to save the lives of others.
And it is a duty on countries to implement. They have an obligation under the Genocide Convention. They cannot escape that.
معالي السفير، ألا تخشى مثلا أن المحكمة لم تعلن مباشرة وقف إطلاق النار؟ ليست خيبة أمل بالنسبة لكم؟
على الإطلاق، كل ما في الأمر هو يدعو إلى وقف إطلاق النار. لا يمكن تنفيذ أمر المحكمة اليوم من دون وقف إطلاق النار، ويجب على إسرائيل أن تبرر نفسها خلال شهر من الآن لماذا لم ينفذ أمر المحكمة. ودون وقف إطلاق النار لا يمكن أن ينفذ أمر المحكمة، لا يمكن إيصال المساعدات الإنسانية، لا يمكن تقليل ومنع الخسائر بين المدنيين، لا يمكن وقف الدمار وما ترتكبه، وكل ذلك كان في أمر المحكمة. لذلك وقف إطلاق النار هو عنصر رئيسي في كل جزء من قرار المحكمة.
Thank you very much. That concludes the briefing.
Thank you very much.
Thank you.
Thank you for your time.
I'm from Tunisia, and I'm sure you honored Nelson Mandela and you honored your country. Thank you very much, madam. Thank you very much.
كيف يمكن ان تصف
ما حصل اليوم ونتمنى أن يؤدوا بشكل عاجل
بن غفير كتب على صفحته على تويتر قبل قليل ان ما جرى هو انتصار كأن اسرائيل ترى ان ما جرى وكانه يصب في صالحها لان ليس فيه دعوه صريحه لوقف اطلاق النار. هل هذا
يعني نتمنى ان نصل للقرار طالما يرى ان
هل رايك ان هذا اليوم هو يوم يمكن ان يسجل لجنوب افريقيا ولفلسطين بانهم استطاعوا نزع يعني شيء من هذا؟
ما امر وما الى ذلك من كل هذه الجوانب كان موجود في نفس القرار ولما وصلت الى المحكمه من اجراءات